Welcome once again to Lehto's Law. Here's Steve Lehto.
I had a whole bunch of people send me a story out of Florida. We talked before about how squatters can move into an unoccupied house, for instance, and when the true owner shows up and calls the police on these people, the police will often show up and go, well, that's a civil matter. They say they live here, and you say you live here, but they showed us some paperwork. We don't know who to believe. And in many places, that'll get tied up in court for a while. And it became a problem during the recession when a lot of homes were unoccupied. That was a problem. And then, of course, during COVID, it became a problem also because many courts delayed hearing landlord-tenant issues, and many of these cases are treated as landlord-tenant issues. And a lot of people have pointed out that that is actually a bit absurd, that someone can squat in a house and then say, well, I'm a tenant because I'm here. And of course, it was just the fact that the courts were overloaded and there were not good laws on the books. So a bunch of people said, Steve, check out the story out of Florida. Turns out Florida's got a relatively new statute that addresses this right on point. They did the right thing. And apparently, a landlord was going through some trouble on this, and he asked around, and somebody said, hey, did you see that statute? It's section 035 of subsection 82 of the Florida statutes. And I pulled a copy of it. I got it right here. And this is fascinating. Now, I do not know the history of the statute other than it's listed as a 2022 Florida statute, including a 2023B statute. And I'm assuming that that means that's when it was quote-unquote published, but it may have been passed a little bit earlier than that. There's a little bit of what we call legislative history indicating there was a prior statute, but the prior statute doesn't appear to have been as good as this statute. This statute says, in Florida, if somebody's squatting in your property, as I described a moment ago, you can oust them by filing an affidavit, and you can take the affidavit to law enforcement and say, I want you guys to go to my house and get that squatter out of there. And this statute specifically spells out when the police can do that, and it takes away their ability to say, oh, it sounds like a civil matter. No. Now it is a Section 35 matter of subsection 82. But it's called remedy for unlawful detention by a transient occupant of residential property. And there's another part called recovery of transient occupants' personal belongings. So you can oust them and they might get their stuff back. But here's the deal. As most statutes go, it's got a bunch of definitions and then it's got some explanations. So I'll start here. And it says that this is a remedy for the unlawful detention, as I told you. And then the transient occupant is what we're talking about and calling a squatter. As used in this section, the term transient occupant means a person whose residency in real property intended for residential use has occurred for a brief length of time, is not pursuant to a lease, and whose occupancy was intended as transient in nature. Now, how they intended their occupancy to be is going to be up for debate. And also, it says not pursuant to a lease. However, as you can imagine, I mentioned before, many of these people will produce a piece of paper and go, look, I have a lease. But if the lease is not with the actual owner of the property, that's not going to fly anymore. So the person has a bunch of factors that will decide whether or not they are a transient occupant. It says, but are not limited to. So there's some examples here that the courts will look at if this ever went to court. A person does not have an ownership interest, financial interest, or leasehold interest in the property. Person does not have any property utility subscriptions. So did they squat and immediately put all the utilities in their own name? If not, they got a problem. Person cannot produce documentation, correspondence, or identification cards sent or issued by a government agency. So they can show up, the police can, and say, show me some ID. They go, I don't have any ID. That's a problem. It makes them transient. Person pays minimal or no rent for his or her stay at the property. So they're squatting in your property and they're not paying rent? Gee, that might be a problem. Person does not have a designated space of his or her own, such as a room at the property. Person has minimal, if any, personal belongings at the property. The person has an apparent permanent residence elsewhere. So when they ask to see the ID, does the ID show that they actually live there, or is it their last address or the place they actually lived at before? So that's all of the things. Notice that it says minor contributions for the purchase of household goods or minor contributions towards other expenses do not establish residency. So now it says, a transient occupant unlawfully detains a residential property if the transient occupant remains in occupancy of the residential property after the party entitled to possession of the property has directed them to leave. Step 1, tell them to get out. So someone's in your house. Step 1, you go say, guys, this is my property, out. If you've done that, you've done that. It doesn't say you got to do it in a particular manner, but you have to tell them to leave. You have to direct them to leave. Then it says, a transient occupancy terminates when the transient occupant begins to reside elsewhere, surrenders the key to the dwelling, or leaves the dwelling when directed by a law enforcement officer. And a law enforcement officer is mentioned there because this statute anticipates that if they don't leave, you go to the cops then help you. And the statute says that. And it says, when directed by a law enforcement officer in receipt of an affidavit under subsection 3. Okay? A transient occupancy is not extended by the presence of personal belongings of a former transient occupant. So the fact that they got their stuff there, number 1, doesn't buy them more time, and number 2, doesn't mean they get to stay. So the affidavit we're talking about is at subsection 3, which I'll now read. Any law enforcement officer may, upon receipt of a sworn affidavit of the party entitled to possession, that a person who is a transient occupant is unlawfully detaining residential property, direct a transient occupant to surrender possession of residential property, period. So you get this affidavit, you give it to the police and say, I need this person out. Now, the only problem I have here, it says that a law enforcement officer may. It doesn't force them to do it. But the fact that the law says they can means that they should, okay? The sworn affidavit must set forth the facts, including the applicable factors, which establish that a transient occupant is unlawfully detaining residential property. A person who fails to comply with the direction of the law enforcement officer to surrender possession or occupancy violates another subsection on trespass, which I'll get to in a second. So it says that you get this affidavit and then you bring it to the police and then they will oust the person for you. A person wrongfully removed pursuant to the subsection has a cause of action for wrongful removal. So if you were to actually oust somebody who had a lease that you had signed with them, you can't use this to break a lease, obviously. A party entitled to possession of real property has a cause of action for unlawful detainer against a transient occupant. So this statute also says that after you oust them, if you want to, you can sue them for damages and presumably back rent. The party entitled to possession of a dwelling shall allow a former transient occupant to recover his or her belongings at reasonable times under reasonable conditions. So there's a process for that as well. Now, if the party entitled to possession reasonably believes the former transient occupant is engaged in misconduct or has a history of violence or drug or alcohol abuse, it is reasonable for the party entitled to possession of the dwelling to impose additional conditions on access to the dwelling. These conditions may include, but are not limited to, the presence of a law enforcement officer, the use of a mover registered with the Department of Agriculture and Consumer Services, or the use of a trusted third party to recover the personal belongings. So keep in mind that they can come get their stuff, but not just willy-nilly as they see fit. And then finally, you should know that it does say, this section shall be construed in recognition of the right to exclude others as one of the most essential components of property rights. And I've mentioned before that you'll often read statutes that'll have a preamble, and it'll say, given the nature of the situation in this field of law, we've decided it needs more regulation to help people and protect consumers. This one comes right out and says, this section shall be construed in recognition of the right to exclude others as one of the most essential components of property rights. I'm surprised they put this in a subsection and not in the preamble, but it's clearly a recognition of that. And that's one of the things that drove people crazy. They go, I buy a piece of property and I find someone's living there and I can't oust them. And that's one of the things you have the right to do with property. You have the right to invite people in or eject people who are there. And so the fact that they're calling that out specifically is really, really good. I'm glad they did that. I did make a copy also of 810.08, which is what they say that you have a cause of action against somebody who does this on your property. And if they don't leave when they're asked to by law enforcement, they're violating this statute. Trespass in a structure or conveyance. Whoever, without being authorized, licensed, or invited, willfully enters or remains in any structure or conveyance or having been authorized, licensed, or invited, is warned to leave the premises and refuses to do so, commits the offense of trespass. And then it talks about what the harms are and what you can do about it. But the point is that it becomes an actual crime. So that's good also. So I do not know how long this law has been on the books. I don't think it's been on the books very long, at least not in this form. It appears to have replaced a slightly different version that had been on the books. But I'd never heard about this law. And I got several emails from people, including one guy who goes, Steve, you guys knew about this all along, referring to lawyers. And he goes, and lawyers don't want people to know the law because you guys make more money when nobody knows the law. I'm not licensed in Florida. If I was in Florida right now, I'd be putting a big page on my website going, do you have a problem with squatters on your property? Contact me. And I would be drafting these affidavits and firing them out so fast, it would cause my printer to smoke. So, no, I talk about the law all the time. I was unaware this law existed in Florida. And I've heard of this problem in Florida. Now, I will tell you that one of the stories I read, including the primary one in this one, said that it's a little-known law, and the guy who discovered it was shocked that he had discovered it, and he was a landlord. And he said that somebody pointed it out to him and said, yeah, there's this law in the books. Did you know about that? And so now it's all over about this little-known law. All of the laws of any state are out there. They're not hidden, okay? I jokingly tell you the blue books behind me are the laws of the state of Michigan. But they're online. Michigan compiled laws, MCL. They're searchable. So you can go onto a state's website. I'm pretty sure most states have done this by now, and search their website looking for laws. And so you would have had to know to look inside the Civil Practice and Procedure, Chapter 82, to find subsection 35, remedy for unlawful detention by a transient occupant of residential property. And so I do have some friends who are attorneys in Florida, but they're lemon law lawyers. I don't know anybody down there who does this kind of law. So I don't know how well known this law is compared to other laws, but the laws are not hidden, and attorneys don't hide them from you. And so if you come into my office, I don't say, well, gee, there are laws on that, but I can't tell you about them, not unless you know the secret handshake. No, I shoot videos about the laws. I talk about the laws in other states. I'm only licensed in Michigan, so the stuff I've got in my head, the stuff I'm most aware of is Michigan, okay? And so the fact that there's an obscure statute in Florida that nobody knows about ain't my fault, and it ain't the fault of lawyers who are hiding it because it's published like every other law out there. So this is a good thing. Other states need to do this. Other states need to do this. And so I will be looking forward to, as more and more people learn about this, especially in Florida, to see what results they get. Because apparently the guy who discovered this and told the various news agencies about it managed to oust somebody after getting the affidavit in the hands of law enforcement, and they went over it and they ousted somebody for him. And oust, by the way, is actually an old legal term. You could actually oust somebody from property, and they refer to that as an ouster. I love the old terms. So as more and more of this happens, I suspect it's going to become more well-known because it's been going on for so long that people could just squat on the property and get away with it, that a lot of people are going to want to hear about the pendulum swinging back the other way and these people getting kicked out like they deserve. So there you go. It's a statute. I'll put a link to the statute in the description below because otherwise there will be some people who want to find it and can't. But it's 2022 Florida statutes, including 22C, 22D, 22A, and 23B, under the title Civil Practice and Procedure, Chapter 82, Section 35. But there is now a process whereby an owner of property can go to the police and say, here's the process. I need you to oust these people for me. You hand them the affidavit and they go do it. And it gives the owner a remedy, which is a good thing, finally. So there you go. Thanks everybody who sent it. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. A sunset paints the sky as if there were no tomorrow.